You may think of bankruptcy as something that only happens to businesses or corporations. Over the past few years, however, it has become an increasingly popular option for individuals who are struggling with debt and would like to make a fresh start. Bankruptcy law in South Africa permits a person to eliminate the majority, if not all, of their debt. You may want to consider this option if you have no remaining assets that can be converted to cash to pay your creditors with. If your creditors have begun to undertake legal proceedings against you, declaring bankruptcy is a way to protect your assets from them. If you have decided that filing for bankruptcy is the right solution to your debt problems, you may be feeling overwhelmed and uncertain how to go about it. There are 9 basic stages of the procedure. Here are some guidelines to help you through them. Stage 1. Visit an attorney who specializes in bankruptcy law. He will help you to file a statement of affairs. Once you have printed a copy of this form, you will need to fill in the following information for each of your creditors. Creditor's name and postal address.
The amount you owe to this creditor.
The reason for the debt, for instance a loan, payment for goods or services. If the creditor is in possession of security for payment, for instance a mortgage, you will also need to list your assets. Your income.
Stage 2. Your attorney will then process and draft the statement of affairs and send you a preliminary copy. At this time you will also arrange for your assets to be valued by a sworn appraiser. The Master of the High Court will appoint a trustee in whom ownership of the assets will be vested once your application for bankruptcy is granted. You may be able to repurchase them at a later date.
Stage 3. Any necessary changes will be made to the statement of affairs. It will then be signed and commissioned. Stage 4. Your attorney will then publish the statement of affairs in the Government Gazette. Once it has been published, you are protected by the Insolvency Act. This means that creditors will no longer be able to claim and sell your property. Stage 5. A court date will be set within 30 days from the publication. Stage 6. Your attorney will then send you statement of affairs to the Master of the High Court. Stage 7. At this point, notice will be given to each of your creditors. Your employer will not be informed, only your employees if you have any. Stage 8. The original document will be sent to Registrar of the High Court within at least 48 hours of the court date. Stage 9. You will attend the court hearing. If necessary, your attorney will appoint an advocate to argue on your behalf. Provided that the court is satisfied that you have met all the required provisions, you will be granted the surrender of your estate and you will be issued with a sequestration order.